You are listening to the Critical Mass Radio Show, Orange County's business talk show, focused on exploring topics of interest to CEOs who are leading middle market companies. With your host, Richard Franzi.
Hello and welcome to Orange County's longest running business talk show. And yes, I am your host, Rick Franzi. I'm excited today because we have a returning guest and a published author, Kent Schmidt, who is a litigation partner at Dorsey. Kent, welcome to the program.
Thank you, Rick. It's a pleasure to be back. It's been many years since I first was on your show. So
right.
It's great to be back.
So it's talking about many years. Let's start with the question that I have for you, which is, what's kept you at Dorsey for 25 years, Kent?
Well, the short answer, and I know you like short answers, the short answer to that is a great place to work. I came to Dorsey at the launch of my career and just passed the 25-year mark actually last week, so coincidentally. Where I work and live is a perfect place. I always say California doesn't just have ocean breezes and palm trees swaying in the breeze. It has the most litigation of any jurisdiction in the world. And New York sometimes, I think, tries to pass us up, but I doubt by almost any measure New York even comes close. New York's a litigious forum as well, but California is a very litigious place. And so I've been out here in California with Dorsey, essentially trying to put out fires for clients around the world. One of the things about being at Dorsey is my practice has an international component to it because we have 3 offices in Asia, 2 offices in Canada, and an office in London. And so I'm routinely called upon to assist clients in those jurisdictions, referrals from partners in those offices. And it makes the work very interesting. It's great to have clients also down the street, but being exposed to different cultures and different business models from around the world makes it interesting. And sooner or later, if you do business around the world, you're probably going to get a suit in California. And so that's what keeps it interesting and never a dull moment. No 2 cases are exactly alike.
So I introduced you as litigation partner for Dorsey. I wonder if you could explain maybe a little bit, put a finer point on what is it exactly that you're doing in your role at Dorsey?
Well, for the most part, my work in actual litigation, as I said, is quite varied. It's more on the defense side than the plaintiff side. I do represent plaintiffs from time to time. It's more for corporations and other business entities than it is for individuals, although from time to time I will represent an individual as well. But for the most part, it is litigating cases, particularly in California, but also around the country, that arise from commercial disputes between parties, or that arise from consumer claims that are brought by companies in class actions or similar consumer protection context. So it is a wide variety of cases, and as happens with most people, my practice has evolved over the years, and you're a significant part of that, Rick. I'll put you on the spot. We interacted about 10 years ago regarding litigation risk when you asked me to speak to your roundtable group about ways to avoid litigation being brought, so what I call the unforced errors. And I did a series of presentations with you, and you were the one that first said to me, you know what you should do, Kent? You should write a book on litigation risk. And my initial reaction was, this isn't something that would be conducive to a whole book. And it seemed overwhelming, particularly with my busy practice. But you were really the one that prompted me to start thinking about an outline. And I started that journey in 2013. So about 10 years ago. And it sort of was on the back burner for many years. We got together for lunch from time to time and talked about our writing projects, the book that you had underway as well. And you were a great encouragement to me. That book was finally published in 2021. No coincidence that it was published months into the lockdown. It would have never been finished. It would not been for being quarantined, the courts shutting down.
Sure.
And it's been pretty transformative to my practice. I still do all of the things I talked about earlier, but an increasing component of my practice is litigation risk advice and litigation management advice. It is issue spotting with clients, again, from around the world regarding the unforced errors, or as I like to say, the trap doors that they're standing on that on a moment's notice could put them into very significant and costly litigation. And not for all of the claims, but for many of these types of lawsuits, there are relatively easy fixes. There are provisions that can be inserted in contracts, limitations on liability, or removing limitations on liability if you're on the plaintiff side in a commercial agreement. There are terms and conditions on websites. There are advertising statements that are made which violate FTC rules and other consumer protection rules. There are assessments of products with respect to product liability risks. There are things that people do innocently enough that create antitrust problems, anti-competitive conduct. Understanding what these risks are is not only a subject of my book, but it's increasingly a focus of my practice. And I find it's been very useful because that part of my practice informs the real live litigation, which is about 70% of my practice. And the real life litigation and the lessons that we learn inform the litigation risk advice. And so it is a nice combination. It keeps it varied. And I'm really grateful that I've had the opportunity to start moving in that issue spotting advice context as well.
It sounds like being proactive. It's the ounce of prevention is worth a pound of cure, maybe in some ways.
Absolutely. And it's, it's pennies on the dollar, spend a little bit of money with someone who's issue spotting and maybe save, a significant amount of money in litigation fees down the road. Some people say, well, aren't you working against your own economic best interest? And
Okay.
I get the point, but I don't think that any amount of my work is going to result in the litigation work drying up.
So you're a published author and you're also a podcaster now. So tell us a little bit about your newly launched podcast.
Well, SharkCast is a podcast that is devoted to those same topics, but the issues that create litigation risk are so quickly evolving and fast moving that publishing something 1 year, some of it becomes obsolete or becomes dated. For example, I published this book in 2021. We weren't talking about AI in 2021. We were barely starting to talk about ESG. In 2021, we were all talking about COVID litigation, which is an interesting topic. But there are new and emerging regulatory regimes in the U.S. and around the world, and particularly in California. And so what I like to do is try to identify those and jump on a podcast episode with colleagues or people from outside the firm, experts that I've used, people in business that are helpful in identifying and tackling these litigation risks, and try to help readers and those listeners that would benefit from perhaps hearing something that's very, very current in addition to considering it in the written form. So SharkCast launched earlier this year. We're nowhere near the episode volume that you are. You've been laboring at this for many, many years. So we are nascent by comparison. But it's been a great experience, and I've had an opportunity to interview a lot of my colleagues on these topics, and I enjoy that exchange and interaction.
So who would be a good audience, or who should listen to SharkCast?
Well, as with the book, the challenge is writing and speaking in a way that is useful not only to lawyers and has has hopefully enough content that lawyers listening to it will find it informative and useful and updating, but also accessible to someone who doesn't have formal legal training. And so we try to tackle these types of issues like data privacy and ESG issues and arbitration. Those are some of the recent episodes that we've had, but yet do it in a way that business owners, entrepreneurs, chief financial officers, those that are in the C-suite or that are just starting out in a new business can really understand, as well as those that are outside the U.S. and are not as familiar with some of the legal processes that we in the U.S. are more familiar with.
So that's a perfect opening for my next question, which I know you're working with international firms. They're opening operations in the U.S. or entering this market. Tell me about the work that you're doing with those class of clients.
Well, look, if litigation risks are a daunting challenge for U.S. companies that read about litigation every day on the front pages of newspapers and have friends and colleagues who have been ensnared in costly litigation, it's even more daunting and challenging for those outside the U.S. So, for example, our friends even just north of the border in Canada are very concerned about entering into the U.S. market, just crossing the border from Vancouver or Toronto or Montreal and starting to sell into the U.S. market because there's obviously plenty of regulation in Canada, but their experience with litigation, particularly consumer class action litigation, is not nearly what it is in the U.S. There's just so much more litigation, much more likelihood of being sued in a consumer class action, for example. And the same for companies around the world, whether it's from Asia or Europe or South America, that are coming into the U.S., not even establishing an office necessarily or engaged in a merger or combination, but just sending product into the U.S., putting up an e-commerce website and starting to sell in product or services to U.S. consumers. They're now faced with significant risk of a potential lawsuit. So one of the things that I like to do is come alongside particularly law firms in those other jurisdictions who are very knowledgeable about the legal requirements for doing business and even the regulatory regimes that they operate in, for example, in the European Union, but are not yet in a position to advise their clients fully on litigation risk in the U.S. They know enough to know that this is a scary line to cross once you enter the U.S. market from a litigation risk standpoint. And so collaborating with those law firms is, I think, mutually beneficial. I learn a lot from them, and hopefully I provide a benefit to them. And I just really enjoy it as well, just the different cultures and different ways of approaching things. It's a significant part of my practice, and I enjoy it expanding.
So I think I know the answer to the question, but I'm going to ask it anyway. You've been doing this for 25 plus years. Your view of is litigation more prominent now than when you started, or has your book made such a dent on being proactive that it's not nearly what it was when you started your practice?
No, but my book hasn't made a dent of any significance into the number of litigation claims that are being filed. The number of claims, the complexity of the claims, the number of I talked a lot about consumer class actions on this. That's a big area of risk. The number of small consumer class action firms out there that are just churning out demand letters, not even filing a lawsuit, just sending a pre-lawsuit demand letter saying your product is deceptive, your advertising is deceitful. We're going to file a lawsuit within the next 10 days if we can't reach a pre-lawsuit settlement. And that is on the rise. And it's, as we say, something old, something new. Sometimes it's just old garden variety consumer deception claims relating to slack fill, like how big a container is versus the product that you get in the container. And then there are brand new claims like, data privacy relating to software that's on websites and tracking of surfing activity and AI and the scraping of data. Those claims are brand new because they're just stemmed from, emerging technologies, but the plaintiffs' lawyers are on top of it. They were on top of it during COVID with the COVID class actions that were just went through the roof, and they're on top of every single new social or technological phenomenon that we face.
So you mentioned earlier when you wrote the book, ESG wasn't a focus and AI wasn't necessarily a focus, and the book came out not that long ago. Can you share with our audience a little bit more about what you're seeing in those two areas as far as litigation?
Well, particularly in AI, I would say the two greatest litigation risks are in IP and infringement context, as well as in consumer data privacy. The AI can be understood in a number of different ways, but one way to think of it is a exponential growth in the data and the uses of data, and it creates questions as to where the data came from and what are the privacy rights that are attached to the data, and are the beneficiaries of the data charged with essentially the equivalency of receiving stolen property. If the data was purloined or was a result of a data breach or came from the dark web, is there some claim that can be brought against those that are receiving the data, even if what they're doing seems very benign and innocent? So that's a whole area. And then, of course, copyright infringement with the manipulation of data and information that becomes indistinguishable from the original work, but yet is still derivative of that. Huge area of litigation.
Right.
ESG is continuing to evolve. It's too big of a topic to tackle in a sentence or two, but I will say that litigation relating to greenwashing or products or services that have a claim relating to their ecological benefits or minimizing the carbon footprint or the materials, the recyclability of the materials. That's a growing area of litigation, because what you have are companies that are adapting to consumers' demands and expectations and to other motivations that push companies in this direction. But then the question comes, are these claims that are being added to products and services relating to the carbon footprint or the sourcing of products, are they valid? Are they deceptive to consumers? So that's just one small slice of the ESG pie. It's a growing area. So we'll continue to see all those types of claims.
Yeah, that's a new frontier, isn't it? Because I can see how the marketing department would want to align themselves with consumer preferences, but the business has to make sure they can stand behind the claims, is what I hear you saying. And
absolutely, like any other claim that's made to consumers.
Right. Wow, powerful. So it's never a dull moment being a litigator, is it, in your life there at Dorsey? I'm wondering, what do you see as the future of your practice? What's next for you?
Well, I'm very reflective right now, having passed this 25-year mark. I am thinking about the last decade and a half, or maybe 2 decades, depending on how much fun I have. I'm envisioning that this litigation advice work and trying to, if it doesn't sound too pretentious, be a thought leader,
Right.
will continue to grow. I still, however, like to roll up my sleeves and get in the courtroom and take key depositions, and I have many more trials in me, I'm sure. But once you get into your 60s, I don't know for sure, but I'm guessing that hauling bankers' boxes of exhibits up the courthouse steps when I'm 65 might not be quite as invigorating as when I was 25. So I may see in the next 10 or 15 years my actual litigation work start to wind down and just do more speaking and writing on litigation risk. And I'm sure 10 years from now, we'll be talking about litigation risks that we can't even begin to imagine and get our arms around. So it is exciting. And as you say, never a dull moment. It's an evolving landscape.
Well, I really appreciate you coming back on the show and sharing your journey. It's great to see you again here on the show. I'm so happy for you and the success you're having with your book. Thanks for spending a little bit of time with our audience. If someone would like to learn more about your book or connect with you or Dorsey, where do you say they go, Ken?
Well, I have all of this information at a website that's easy to remember. It's Litigation Risks with an S, because there are multiple risks. litigationrisks.com. The SharkCast episodes are there, how to order the book, and contact information from me.
One-stop shopping. I like it. Make it easy for people to get all your IP. That's fantastic. Well, again,
thanks again, Rick. I got to say one more time, it's amazing how one conversation, one thought, coming from someone like you can change the trajectory of someone's career and life. And it's been 10 years and here we are. So thanks for encouraging me to write the book. I really feel like I owe a debt of gratitude to you.
Well, thank you for saying that. I appreciate it. I'm happy to be a positive influence for you, my friend. And I look forward to getting together with you and catching up offline. So we'll do that after the show is over. Thank you for your time.
Thank you, Rick.
And I'd like to thank the audience. You're a part of Orange County's longest running business talk show. Kent's episode now becomes a part of our catalog. As he mentioned earlier, we have over 1,400 interviews. If you're an Orange County entrepreneur and you have a story to tell, then reach out to me on LinkedIn. I'm Rick, R-I-C, Franzi, F-R-A-N-Z-I. Coincidentally, that's also my company's website, rickfranzi.com. And so if you reach out to us, Haley and I will be happy to talk with you and see if it's appropriate to have you on a future episode. And until we have a chance to be together again, I hope all of your business decisions will move your company in a positive direction.